Hi, thank you for coming. Whatever we discuss is privileged and confidential. No one is going to know the content of our conversations. Let me see what you brought with you, Mr. Perez. All right. The police are claiming you were in possession of under 50 grams of marijuana. And interestingly, they have issued not just a disorderly person's complaint that appears as a violation in our criminal statute book. They also issued a summons to you, a ticket to you, charging you with a motor vehicle violation in Title 39 of our statutes for possession of a controlled dangerous substance in a motor vehicle. Let me discuss with you first what the potential penalties are that you face, and then I'm going to tell you what it is that I'll be able to do to help you in this matter. First, a disorderly person's offense for someone with no prior convictions carries, nevertheless, a maximum 6-month jail term in the county jail. There is a $1,000 fine. There is a drug enforcement demand reduction penalty of $500. There are additional monetary penalties to the Safe Neighborhood Fund, as well as to the Victims of Crime Compensation Board. There are laboratory fees. There are what are called DARE fees for drug education in the high schools. You also are facing a 6 to 24 month loss of your driving privileges. You're not entitled to a jury trial, but by the same token, this is not classified as a crime in New Jersey. Even though it's in our criminal statutes, it's a disorderly person's offense. Interestingly, the ticket that you received can result in even greater penalties to you. It's a motor vehicle violation that carries a fine, but it also carries a mandatory 2-year loss of your driving privileges. Now, if this is your first offense, there's a variety of ways we can explore this. You're entitled to all of the constitutional rights that you would have if you were charged with a crime. The state has to prove each and every element of this offense beyond a reasonable doubt. We're entitled to cross-examine witnesses who testify against you, present witnesses who testify for you. We can have you exercise your Fifth Amendment privilege to remain silent. We'll be entitled to a fair trial, but it won't include a jury. No plea bargaining is permitted in these cases, nor is it permitted in DWI cases. So we're going to have to face these charges head on. And if you have previously had diversionary treatment, you won't have that available to you in this particular instance that would otherwise possibly have led to a dismissal of your charge. If this is your first offense for a minor drug violation in New Jersey and anywhere else in the state or country, that is something that is an option that we can consider. But I want to first see whether or not we have a complete defense to this case. One of the things that you're also entitled to is the right to remain free from unreasonable searches and seizures under our Fourth Amendment. So I want to look at the police records and reports very carefully that I'm going to order so that we can evaluate whether or not that constitutional right that you're entitled to is violated. And if we were successful in doing that, the drugs, the contraband, would be excluded from evidence and the state would be left with no proofs at all. That will be done in a pretrial proceeding called a motion to suppress evidence. Also, I'm going to want to look very closely at the chain of custody and whether or not the state is able to prove through the chemist that there actually was a controlled dangerous substance or marijuana in your particular case that you were in possession of. They also have to prove that you were in knowing possession of that marijuana, because this is a disorderly persons offense in our criminal statutes, the element of criminal intent comes into play as well. I'm able, through my over 30 years of experience in handling thousands of cases like this, to be able to determine whether or not the police chemist is going to be able to establish that this was marijuana. And we're going to be able to go over all of the various tests that were employed and all of the chemist's notes that were utilized in an effort to avoid them from presenting this as evidence. That would include mass spectroscopy, for example. It might include, in some instances, other diagnostic tests that I'm very well familiar with. We may want to hire our own expert witnesses to assist us in this case. The next time we speak is going to be when I receive these records and reports. In the meantime, I want you to remain in contact with me, and I will with you. You'll receive copies of what I send in the mail. We'll be able to communicate in person, by phone or email. I take my representation of you very seriously, and that's why my moniker is I Defend You. So I thank you very much, and I look forward to working with you.
To begin the defense of your case, you can schedule an appointment with attorney Richard R. Uslan for a free consultation. Just call toll-free 24 hours a day, 866-433-3638. Leave a message after business hours. Remember, you are absolutely entitled to a defense of your case. Your defense can begin right now by calling attorney Richard R. Uslan.